Tonight, new developments in the former president's New York civil fraud case. Trump requested a delay in paying the $355 million penalty, and now a judge has said no. CNN's Kara Scannell joins us now with the latest. What was the reasoning the judge gave?
So Trump had asked for this delay because of the magnitude, this $355 million judgment. And the judge said that he did not provide, as he put it, he failed to explain, much less justify, any basis for a delay. And this is because the New York Attorney General's office had written up a proposed judgment, and they were saying they wanted some time to look at it. The judge is saying this matches my order exactly, so we're going to move forward. So he indicated to the parties in an email that he was going to now finalize this judgment because, as we know, the ruling came down Friday, but it doesn't really become official until it's entered into the docket. So the judge noted on the docket that he was doing that, but it still has to get processed by a clerk. And once it is finally entered, which could be as soon as tomorrow or it might take a couple days, then this will become official.
It was supposed to be a routine procedural step in one of the most closely watched legal cases involving Donald Trump. But what happened next quickly turned into a major legal development that could have serious financial and political implications. Just days after the ruling from Arthur Engoron, the judge overseeing the high-profile civil fraud case in New York, a new dispute emerged inside the courtroom process. The decision had ordered Trump to pay roughly $354.8 million, a staggering figure tied to the state's civil fraud findings. Once interest is included, the total amount could approach $455 million. But before the legal clock could even start ticking, Trump's legal team attempted to slow things down. According to reporting discussed on CNN, Trump's lawyers asked the court for a 30-day delay. Their argument centered on the legal process itself. They claim that the proposed judgment submitted by the office of Letitia James, the Attorney General of New York, had been filed without giving Trump's defense team enough opportunity to respond with their own version of the judgment. In complex legal cases like this, that step can matter. The proposed judgment is not just paperwork. It transforms a judge's written ruling into the formal, enforceable order that gets entered into the court record. Until that happens, something critical remains paused: the clock. Once the judgment is officially entered into the court docket, several deadlines begin immediately. The defendant typically has a limited window to file an appeal and to secure a financial bond guaranteeing payment if the ruling is upheld. For Trump, that potential bond could be enormous. When penalties and interest are combined, the total financial exposure could reach around $455 million. Posting that bond could involve cash, a bond company, or assets used as collateral. So Trump's legal team asked the court for more time. But the judge's response came quickly, and it was strikingly brief. In a message addressed to Trump's attorney, Judge Engoron rejected the request outright. The reasoning was direct. The defense, he wrote, had failed to explain, much less justify, any basis for a stay. The judge also signaled confidence that the appellate courts would protect Trump's legal rights during the appeals process, suggesting there was no need to delay the entry of the judgment. In other words, from the court's perspective, the process should move forward. Engoron indicated he intended to sign the version of the judgment submitted by the Attorney General's office, explaining that it accurately reflected both the spirit and letter of his earlier ruling. There were only minor disputes raised by Trump's legal team. One involved the start date used to calculate interest related to former Trump Organization executive Allen Weisselberg. The judge noted that issue had already been corrected. Another involved the listed business addresses for several Trump-related entities. The defense wanted 6 of those addresses changed from New York to Florida. But the judge said there was no evidence that the existing information in the judgment was incorrect, so the request was denied. Still, even after the judge signed the document, the process was not quite finished. The judgment must still be processed by the court clerk before it becomes officially entered into the public docket. Only then does the legal countdown begin. Once that happens, Trump would typically have 30 days to file an appeal and 30 days to post the required bond tied to the ruling. And timing could be critical. If the judgment becomes official soon, the deadline to secure that massive bond could arrive just as Trump faces another major legal moment: the criminal trial in New York connected to hush money payments involving Stormy Daniels. That means 2 major legal timelines could begin running almost simultaneously, one civil, one criminal, creating a complex and high-stakes moment in the ongoing legal battles surrounding the former president. For now, the final step remains procedural: the clerk's official entry of the judgment. But once that happens, the countdown begins. And with hundreds of millions of dollars potentially at stake, the next moves in this case could draw even more attention to a legal fight that is already being watched around the world.
So the clock starts ticking once it's finalized.
That's right. So from whenever it is finalized, Trump will have 30 days to appeal and 30 days to post $355 million plus $100 million in interest. So a lot of money. He'll have to put that together either by posting the cash himself or getting a bond that can be backed by collateral, some of his properties. But he'll have, about 30 days, and that includes the weekends. So if you kind of can guesstimate if this judgment does become final soon, that means he could have to foot this bill right when he's about to go to trial on the criminal hush money charges.
In moments when major legal cases unfold in public view, it is often the dramatic rulings that attract the most attention. Headlines tend to focus on the numbers, the personalities involved, and the immediate political implications. Yet sometimes the more revealing details are found in the procedural steps that happen quietly between rulings. Those moments, emails between lawyers, proposed judgments moving through a clerk's office, disagreements about wording, may appear technical on the surface, but they often shape the timeline of what happens next. One such procedural moment appeared to arise shortly after a major civil fraud ruling involving Donald Trump in New York. The case, brought by the office of Letitia James, the state's attorney general, had already drawn intense public interest because of the scale of the financial penalties that were being discussed and the broader questions about business practices at the center of the lawsuit. From the outside, it might have seemed that the case had already reached its decisive moment. A judge had issued a ruling. The numbers associated with the judgment had been widely reported. Commentators and analysts across television networks and online platforms began debating what the outcome might mean financially, politically, and legally. But within the legal process itself, the next step was still unfolding. Observers familiar with civil litigation sometimes point out that after a judge issues a written ruling, there is often another stage before the decision becomes an enforceable judgment on the court record. Lawyers may discuss the exact language of the final order, and the document that ultimately appears in the official docket may be the result of negotiation, revision, or competing proposals from the parties involved. That procedural moment appeared to be the subject of disagreement in this case. According to reporting discussed on CNN, the Office of the Attorney General submitted a proposed version of the judgment to the judge overseeing the case, Arthur Engoron. In many situations, legal teams exchange drafts before a final version is sent to the court. The idea behind that practice is relatively simple. Both sides have an opportunity to suggest changes or raise objections before the document is signed. In this instance, however, lawyers representing Trump appeared to argue that the proposed judgment had been submitted without the kind of back-and-forth discussion they expected. From their perspective, this raised questions about whether the defense had been given sufficient notice or time to review the language of the order. From another point of view, the dispute might have seemed narrower. If the proposed document accurately reflected what the judge had already ruled, the question might simply become whether there were specific factual or technical issues that required correction. In situations like this, judges sometimes ask the parties to identify concrete objections. If errors exist, they can be addressed. If not, the judge may proceed with the document that most closely matches the ruling that has already been issued. That appears to be roughly the direction the process took. Reports suggested that the judge indicated the proposed judgment largely reflected the earlier decision. If there were specific disagreements, the defense could point them out. Two issues were reportedly raised in response. One involved the date used to calculate interest related to financial matters connected to Alan Weisselberg, a longtime executive associated with the Trump Organization. Questions about how interest should be calculated are not uncommon in complex financial cases, particularly when the events being examined stretch back over many years. Another issue concerned the listed addresses of several business entities connected to Trump. Lawyers representing the defendants suggested that certain addresses should be listed as being in Florida rather than New York. At first glance, that might sound like a minor clerical detail. Yet legal observers sometimes note that the location associated with a company in official court documents can matter when it comes to enforcement actions, liens, or other mechanisms used to collect a judgment. Whether that concern would ultimately change anything in practice is a separate question, But the issue illustrates how even small pieces of information can carry weight inside a legal system built on precise documentation. The judge reportedly addressed these objections directly. One of the issues was described as having already been corrected. The other, according to reporting at the time, was not accepted. From a commentator's perspective, the exchange might illustrate a broader dynamic in complex litigation. When cases reach the stage where large financial judgments are involved, both sides tend to scrutinize every detail. The language of a judgment, the dates attached to financial calculations, and the formal record of where companies are located may all become points of debate. Another layer of the story concerns timing. Legal procedures often run on what might be described as multiple clocks. One clock might relate to when a judgment becomes official on the docket. Another might involve the period during which an appeal can be filed. Yet another might determine when enforcement actions can begin. For viewers following the case through news coverage, these overlapping timelines may appear confusing. Yet within the legal framework, each one serves a specific purpose. In many civil cases in New York, once a judgment is officially entered, the party that won the case may begin the process of collecting the amount awarded. However, defendants who plan to appeal often have a way to pause enforcement if they provide a financial guarantee known as an undertaking or bond. The concept behind such a bond is relatively straightforward. It functions as a form of security, ensuring that if the appeal fails, the judgment can still be paid. In theory, the bond protects the interests of the party that won the case while allowing the appeal to move forward without immediate collection actions. In practice, however, the size of the bond can become a major issue, especially when the judgment itself is extremely large. Commentators discussing the case noted that when interest calculations were included, the potential financial exposure could reach several $100 million. That figure alone was enough to spark debates across legal and financial circles about how such obligations are typically managed. One technical aspect that drew attention was the statutory interest rate used in New York civil judgments. Under state law, interest may accumulate at a rate of 9% annually. Over time, particularly when the principal amount is large, that rate can produce significant additional sums. For people accustomed to thinking in yearly terms, 9% might sound like a simple percentage. Yet when converted into daily figures on a very large amount of money, the number can appear striking. Legal analysts sometimes explain that the purpose of such interest rates is not necessarily to punish, but to ensure that the party entitled to the judgment is compensated for the time value of money while appeals or delays occur. Still, the mathematics can be dramatic. Each passing day can theoretically add thousands or even tens of thousands of dollars to the total amount owed. For public observers watching the case unfold through news reports, those daily calculations often become a symbol of how quickly financial obligations can grow within the structure of civil law. The story also intersected with other legal proceedings involving Trump. Around the same time period, attention was focused on a criminal case related to payments connected to Stormy Daniels. That case, which involved allegations concerning business records, was scheduled for trial in Manhattan. For commentators, the convergence of these legal timelines created an unusual moment. It was possible to imagine a scenario in which multiple major legal developments could occur within a relatively short span of weeks. Another figure whose name frequently surfaced in discussions of both matters was Michael Cohen, a former attorney for Trump who had previously provided testimony in various proceedings. Because Cohen had been involved in aspects of the financial and political events under examination, some observers saw him as a link between different legal narratives unfolding at the same time. From a media perspective, that overlap may have influenced how news organizations structured their coverage. Segments discussing civil litigation might transition into discussions about criminal proceedings, creating the impression of a broader legal landscape rather than isolated cases. Beyond the courtroom drama, there were also questions about how large financial judgments interact with the realities of wealth and liquidity. Public discussions about billionaires often assume that enormous sums of money can be moved quickly. Yet financial analysts sometimes caution that wealth tied up in real estate or business assets does not necessarily translate into immediate cash. Properties, for example, may have substantial market value, but cannot always be sold rapidly without accepting significant discounts. When legal deadlines require financial guarantees within weeks rather than months or years, that distinction between total wealth and liquid assets may become especially relevant. For commentators examining the situation, that dynamic could create an unusual paradox. A person might be described as extremely wealthy while simultaneously facing logistical challenges in meeting short-term financial requirements imposed by court procedures. Whether that tension would ultimately become decisive in the case remained uncertain at the time. What seemed clearer was that the legal process itself was continuing to move forward step by step. Judges sign orders, clerks process entries, lawyers prepare appeals. Each stage carries its own set of deadlines and obligations. From a distance, the system can appear slow. Yet at certain moments, particularly when deadlines converge, the pace can suddenly feel very fast. For viewers following the story through news broadcasts and online commentary, the procedural details may have seemed technical, but those details were precisely where the next phase of the case was being determined. In the end, legal stories often unfold not as a single dramatic event, but as a series of incremental steps. Each document filed with a court, each ruling issued by a judge, and each argument presented by lawyers adds another piece to the larger narrative. For commentators watching from the outside, the challenge is often to interpret those steps without assuming outcomes that have not yet been decided. What can sometimes be observed, however, is the broader pattern. Multiple legal processes moving at once, financial stakes that appear unusually large, and a political environment in which every procedural development becomes part of a much larger public conversation. In that sense, the procedural dispute over a proposed judgment may have been only one chapter in a legal story that continued to evolve long after the headlines of a single ruling had faded.